Gratitude and love. Thank you, sir. Thank you, ma'am. Sir, I would Asia's USA 2007 and 2017. He has been professor of law at various universities of repute in India and abroad as well, including the University of Pune, National University Jodhpur, Rajiv Gandhi School of Intellectual Property Law, Indian Institute of Technology Kharagpur, Adidas Ababa University, Ethiopia, the University of Technology Mara, Shah Alam, Malaysia, the National University of Malaysia, Bangui, Sultan Sharif Ali Islamic University, Brunei Darussalam, and Berman University, Germany. He has also served as UNDP Professor of Law, Public Law in Ethiopia. He has also served as the Head of Department of Law in University of Pune, the Director for the Center for Criminal Law Studies, National University, Jodhpur, and Dean at Rajiv Gandhi School of Intellectual Property Law and Indian Institute of Technology, that is IIT Kharagpur. Professor Vibhute has authored as well as edited 11 books and has also contributed to 16 anthologies. He has also, to his credit, 119 articles published in reputed law journals across the globe. He has also contributed to the ILI's prestigious annual survey of Indian law. Many of his books are published by Nexus, Butterworths, and Eastern Book Companies and are prescribed as textbooks in Indian as well as in foreign academics. His latest publication includes Phillips Criminal Law, Halsbury Laws of India, Criminal Law, Halsbury Laws of India, many volumes, including the 12 and 12-2, Criminal Procedure and Criminal Procedure Code by D.D. Basu. He has also participated and...
Good afternoon. Thank you for all the nice words which spoken about me. Dr. Pai was a student of my department when I was not there. In fact, it's unscheduled sort of interaction. We can say it's unscheduled, unsolicited interaction with you. I'm supposed to be here at 11:30, but I took a longer time or delayed. So just this informal interaction with you. If you have any questions, please feel free to talk about it. Legal issues, of course. As I said, this informal interaction with me because I wanted to see the department which was headed by stalwarts who entirely taught me when I was a student, C.C. Raghavan sir. So I am urged to just see the campus and meet Dr. Pai, who was a student of, and she was part of our law department when I was there. There was an urge to just to see and say hello to her, and then I'm here. I'm here on the way back to my flight. That is the reason. Okay, now if you have any questions, informal, please talk to me. I'm not going to speak on a specific topic because it's not scheduled. Okay.
So we can say anything related to research you want to ask?
And I'm told that you refer my book.
Yeah, whatever I teach you in legal research, most of the content is from Professor Vibhute's book. So they should
And I was invited as symposium last there yesterday. And today I'm returning back to Pune. So I privilege to talk to her and see the way to be here for a short time. So unplanned, unscheduled visit to the
But it is unplanned, unscheduled, but a destined visit. So we should be thankful to it. So any queries?
Or we require a new horizontal accountabilities about each other in the society. So, what kind of research questions can be formulated bringing with the research?
No, it can be seen from two ways. One is sometimes societal need demands for a new law. Sometimes new law molds the societal behavior. The Uniform Civil Code, which is there in the Constitution, probably you know that which article? Article 44 was inserted in the Constitution. We have Uniform Civil Code, Uniform Civil Matters. So in that case, the founding fathers of the Constitution were anticipating or expecting kind of uniform laws for all the faiths, even though we do believe in secularism. But they thought that there should be some kind of uniformity in personal laws. And even though that attempt was made, but it could not succeed. Now Modi government is making an attempt to bring uniform civil code, but a lot of resistance. Maybe resistance may be political one, or maybe societal one. But those who teach law and social transformation, they realize that sometimes society demands new laws, and sometimes new laws are implemented in society to mold the behavior. The uniform civil code may be in the second category.
We see that there are a lot of changes in the constitution.
In fact, probably you know that contents of a given law or emerging law is left to political wisdom. Most of the times, political wisdom guides the contents of law. And therefore, generally we say political scientists and the politics or government of the day decides the broader framework of law, and what contents are given based upon that political philosophy or political ideology of the government of the day. So it is difficult for us to anticipate and comprehend the contents of a new law unless it comes in the form of bill and then we can deliberate about it. But nobody knows so far what are the contents of uniform civil code. Only we are talking about that there will be uniform civil code. The contents are not known to us. And the Constitution is silent about the contents of it.
Another aspect of that I have told you is some mutual accountability about each other, because fundamental right mostly we see that they are against the state. But if the new system is to be evolved in a privatization, like most of the jobs are now private oriented, so do the employees do not have the rights against that private employer, or do we require some mutual respect of law, like our data is mostly with the international companies? So do we see the emergence of new jurisprudence where the private persons are accountable to each other?
No, but if you see some of the judicial pronouncements, there are indications that fundamental rights are applicable even in private concerns. But Article 19.2 is there. Article 19.2 is there, which talks about reasonable restrictions on the fundamental rights. It requires a lot of deliberation, in fact, in-depth deliberation to answer this question.
There is one more just emerging question which may be out of context. When we have evolving artificial intelligence, so can we make it accountable to the duties as well, or it is also holder of a right in the future to come?
Well, in fact, that we were talking about it in the morning, that whom are going to be responsible. For example, Arizona, there was an accident, self-drive car was there and there was accident, there was death. Now, if you look at the penal code, culpable homicide is there. But now, to whom you are going to be responsible for this kind of? Now, are you going to be responsible those who have created a software, those who assemble the software, or those who have executed the software? To whom you are going to put responsibility? Therefore, there are evolving areas. So we need to wait for some time to come up with kind of legal philosophy which will come into in existence.
In such case, can we extend the personality theory to an extent where
To some extent, but ultimately those theories have to be approved and accepted by the judiciary. Suppose you prosecute someone, and judiciary try to give its juristic input that to whom are going to be responsible for this kind of mishaps.
we can apply the fiction theory to it? Fiction theory.
Yeah, fiction.
Juridical fiction.
This is all mathematics. Here is all mathematics. Yes, please.
Sir, how to research when the data are not available or previous research are not available? Then how to research on that topic?
Then you have to come up with your own methodology and you have to draw your own conclusions. That will be kind of remarkable contribution. When nothing is there and you come out with certain kind of theories, there is going to be a remarkable contribution.
And who will authorize, sir?
Huh?
Who will authorize that research is better? Or
Authorize in the sense?
that is a new thing. Who will authorize that?
Who will validate it?
Who will validate it?
Yes.
No, it's not question valid. Subsequent researcher may validate it. They will destroy the theory which you come up. Or they may add it or they may validate it. But your job is that to bring new things. Let others work on it and validate it or dislodge it.
Sir, he is researching in blockchain technology and cryptocurrency. That's why he is asking. So there is no legal norms of cryptocurrency.
Cryptocurrency bill is there. No, already bill is there. You can look into the bill proposed law and try to find out what kind of thinking or philosophy is there in the bill. You can work on that. The bill is there, is it not, on cryptocurrency? Bill is there. Bill is there.
It is there, but sir, at in taxation provision is also there and under the PMLA is the provision is also there. So yes, we are moving towards the legalized.
Yeah. Dr. Pal must have told you when you do research neurology, if you handle the virgin area, the possibility of contribution is more from your side.
Right,
It is a remarkable contribution. Remarkable contribution.
Thank you, sir.
This extempore interaction. The questions are predetermined, the response are predetermined.
Yes. We will cover all the possible law areas we study. If there is a conflict in public interest and private interest, and we are willing to create a focal point, up to which we go with the private interest, and thereafter we want to see a public, we want to look into public interest. So is there any possibility that we can judge this? What criteria shall we look for? To make precise to my question, when we talk about IPs, we talk about monopolistic interests. But sometimes we want the intellectual property public interest more than a private person. But the monopolistic rights are always valuable. So if I wish that IP should be more into public interest and lesser into a private as an owner's interest. So is there any criteria we can consider where I can look for public interest to the future?
Let's see, primarily public interest overrides the private interest. That is basically nice. If you look at the Patents Act, if you look at section 3D, which talks about the criteria for getting patents. There has to have a novelty, commercial aspect of it, some kind of innovation. So these are the things which you need to do with the patent office to get a patent. But generally theoretical premise is that public interest overrides the private interest. But it's very difficult theoretically to distinguish between what is amount to private interest, what is amount to public interest. It depends upon the context in which you are looking at it.
When it comes to copyright, it may not be so much required in public interest.
But in case of copyright, basically there is a fair use doctrine is there.
Exactly. We have
Fair
options.
use doctrine is there. Now, what does amount to fair use? Ultimately, if there is conflict, the umpire is there, court is there to take a decision. Fair use or not? That this topic becomes very interesting in research, plagiarism, because plagiarism is a kind of research ethics. You should not steal ideas and expressions of someone else, and if you want to use in research, you should duly acknowledge that source. But fair use doctrine is there in the Copyright Act. If not mistaken, section 57, I think. If I'm not mistaken.
51 and 57.
Yeah, if I'm not mistaken.
So there's something related to criminal law. So I just wanted to know how far would your doctoral research in a topic which is related to criminal law would be more successful? Will it be successful? Or if it's a topic on which you cannot actually have surveys in it?
For example,
sir, my personal topic I'm doing on marital rapes.
okay, section 2 to section 375.
So doctoral research, because you cannot go on a field research.
Okay.
So how would it be successful? There is no other means. Are there any other means except for doctoral research?
You look at the social aspects of it.
Yes, sir. But
In fact, if you see my book, which has come 50th edition now, and I'm working on it, see, basically if you see exception 2, section 375, it is controversial. Premise is that even a prostitute can say no, but wife cannot say no to husband. This is a very interesting question to probe in. Now, is a wife lesser than a prostitute? Because if you look at judicial pronouncements, wherein it has recognized and prostitute has right to say no. But a wife doesn't have right to say no to her husband. Now, is it gender-wise, ethically wise, socially wise, philosophically wise to deny this kind of right to say no to a husband, to a wife simply because she is married to someone else? Now, this is a very controversial issue which we need to. But if you look at the new bill of 2023, even they have retained that provision. They have retained it.
Sir, and another thing, not even there is a comparison which we will be doing between a prostitute and a wife. But again, after the independent third case, it's like wife below the age of 18 years can also say no, but
Yeah.
not above the 18 years.
Yeah, that is what
That is also-
Independent Thought Union of India. But nevertheless, but if you look at Independent Thought Union of India, the Supreme Court has very categorically, it is for the Parliament to change, not for us. But sometimes you see a judicial ambivalence. Now when it came to 497, Supreme Court declared unconstitutional. At that time they did not say it's for the Parliament to decide. But when it came to marital rape, they said it's for the Parliament, not for the Commission to decide. Now is it not double standard? Double standards. When they want to intervene, they did intervene, and when they don't want to intervene, they did not. Probably they also wanted to have this exception to remain alive. That's the only
There is a
possibility.
husband in every judge.
And the dominating husband. But see, now this is a good topic for you to prove judicial behavior. Now sometimes judiciary goes extra miles to declare particular law unconstitutional, but sometimes judiciary turns a blind eye. Generally I give this example in my research class. Sometimes they turn a blind eye. And marital rape is one of the examples where Supreme Court did hands off. It said it's not for us, it's for the Parliament to decide. But when it came to adultery, they were very quick to declare it unconstitutional without visualizing the implications of that. Now 497 you look at very carefully. Now, of course, there's a philosophical objection that the wife used to be chattel because only husband has a right to take action against the person who has transgressed into marital life of someone. Because woman is assumption is that woman can be easily seduced. That is assumption. And based upon the assumption, if you look at the judgment, they try to take this assumption further and declare constitutional. They claim sexual autonomy of the individual without looking at the consequences of this kind of. So therefore it is a judicial ambivalence, I say. If you read my new book where I try to comment upon judicial ambivalence.